Zoran Tasić, he's a lawyer. He is the child of the shipyard in Split, working there for many years in the sales department with ship building contracts and financing. At those Asian times, the shipyard was on the top level in former Yugoslavia and now in Croatia. Afterwards, he worked in London for many years, I think almost 15 years, 17 years in London at Stevenson Farm, a large solicitor firm, which was at the same time a sort of meeting point of the Croatian community over there, shipbuilders, ship owners, marine insurance, and so on. Afterwards, he changed to another solicitor firm. Then he returned home, working for a few companies, banks, obviously with the subject matter shipbuilding and ship finance. And then finally he returned on the crime scene at the shipyard, working as a consultant. The glory is yours.
Thank you, that's a little nice friendly words. And thanks to the organizer for having me here today. Ladies and gentlemen, this is the title of my presentation. We heard quite related things last couple of days from Ian Ferrick's presentation on judicial sale, from Juan Pablo's presentation when he mentioned the judicial sale in the context of a charter, federal charter. When I listened to that, when I was listening to it, I thought, it's a nice path to my presentation here. It is almost impossible these days, or any days in the past really, to imagine any ship trading without being subject to mortgage. It is equally almost impossible to imagine any ship trading without being subject to any contract like time charter or voyage charter or arrangements like a bareboat charter. So I'm going to go very quickly to each of those two, not in details because you all know about ship mortgages, so I don't want to bother you with too many details, but just few main features of each. So mortgage is a proprietary interest in the vessel. Although it's based on a contract, on a mortgage agreement between the two, mortgagee, ship owner, and the bank, mortgagee, it actually creates a proprietary interest in the vessel. So much that in a long history ago, the English Merchant Shipping Act was actually treating mortgagee as the owner of the vessel. He had full control over the vessel. These things changed throughout history, and now it's mortgage is just a security for the lender for their claims under the loan agreement or other terms of financing. The other feature related to mortgage, as you all know, it's a registration. Although mortgage is not created by a registration, it's created by an agreement, mortgage agreement between the parties, and there should be enough between the two. However, there are two reasons why they want mortgage to be registered. One is by doing so, you are preserving ranking position of your security against any other potential registrable charges of the same vessel. And second reason is banks want the rest of the world to know that their ship is mortgaged to their favor. So keep your hands off. Registration of mortgage was finally, I would say, well established by the UN Convention on Mortgages and Liens, which convention was a result of a long-term need to improve conditions for ship finance. There were always banks and investors who were ready to finance ships, but securities were always, question of securities was always dodgy, unclear, etc. So this convention helped a lot to finance community and to maritime community to have mortgage defined, how it works, who is in charge, which governing law, etc., etc. So just two brief aspects of the convention is that the law of the state of registration of the ship shall be determinative for the purpose of recognition of regulatory law. So no doubt which law is relevant for the recognition of mortgages. Equally, mortgages are effected and registered in accordance with the law of the state in which the vessel is registered. I would like you to bear in mind these principles throughout my conversation, because later on you'll see that there are, in situations which I'm going to talk about, there are other laws conflicting here and creating sometimes serious problems. In accordance, in line with these provisions of the convention, you will see in mortgage agreements worldwide standard form, which says this mortgage shall be governed by and construed in accordance with the laws of IG, Liberia, Spain, Croatia, Marshall Islands, whatever. All these countries being the state of registration of the mortgage. Few words about the charter. Again, you all know about charter, time charter, voyage charter, etc. But just to make it different from mortgage agreement, this is subject to equitable jurisdiction. It's pure contract between the two, the owner and the charterer. It doesn't create any proprietary rights in respect of the vessel to either of them or to anybody. It's pure contractual rights and obligations written in the contract. Bareboat charter is somehow as a special invention, I would say, because if you read BINCO back on 2001, one particular provision, which reads that during the charter period, the vessel shall be in the full possession and at the absolute disposal for all purposes of the charters and under their complete control in every respect. This sounds almost like ownership. Owner has full possession, absolute disposal, and full control over his vessel. The only difference is that the bareboat charter is not registered as the owner. It is the owner who appears in the ship's registry as the owner. But again, this is very particular arrangement, and it will have particular references in the cases I'm going to refer later. So it's not very nice to start with the defaults, but this subject leads us towards my core of my presentation. So defaults and parties' rights under the mortgage are governed by the law of the state of registration. As we said earlier, state of registration is the governing law for execution, recognition of mortgage, and also defines defaults and remedies under the mortgage agreement. I added, and regardless of bareboat charter registration in different registries. Why? Because you all probably know that there are certain jurisdictions which also offer so-called bareboat registration, meaning that the original state of registration remains as it is, and during the period of the charter, temporarily, that ship can move only temporarily out of that jurisdiction to another so-called bareboat charter registration jurisdiction. Important thing is that the mortgage as registered, the state registration stays as it is. It's not affected by the move of the vessel into bareboat charter registration. So you have defaults of the mortgagor, the owner, governed by the state of registration of the country, original country, and then you have defaults in parties under the bareboat charter governed by the law chosen by the parties. Please bear this in mind when we come to later particular situations. I will refer in my presentation mostly to English law for two reasons. One reason is that charters and bareboat charters and time charters, which are normally in use, and we providing they are also using the PINCO standard form, they are mostly governed by English law. That's one reason. And the other reason is that certain court decisions, English court decisions, we will see later, have been accepted as a guidelines, really, in many other jurisdictions. They like the approach of these English courts in other countries, and they are trying to follow it. That's why I'm referring my presentation mostly to English law. Now, we are all well aware of what typical mortgagors or ship owners defaults are under the mortgage. First of all, this is a non-payment or non-repayment of the loan. Inability to perform certain covenants which they agreed in their mortgage agreement, which inability to perform often may lead to breach of such covenants. Actions by the ship owner which might lead towards the impairment of bank security. These actions might appear to jeopardize the bank security. And also exposing of the vessel to maritime claims. We've had a lot of this during these couple of days of maritime claims. And the bank, no bank is very happy to see that the ship is exposed to maritime claims, which might lead further to arrest and other problems which banks don't like to see at all. What are typical defaults under charter or bareboat charter agreements? Ship owners' defaults are normally delay in delivery, when the ship owner fails to deliver the vessel to the charter on time specified in the charter agreement, as well as any form of depriving charterer from the use of the vessel in one way or another. Once the ship is subject to charter agreement, the charter is free completely to operate the vessel in accordance with the terms. Charters also can commit default, and they do. And one of them basically is non-payment of hire, breach of trading restrictions written in the charter agreement, breach of terms of insurances, which might lead to that the ship remains uninsured, goes into excluded zones, for example, where the insurance says from now on the ship is not covered by us anymore because they're in breach. Breach of duty to maintain and repair the vessel. These are also quite typical breaches of the charter. So, what rights and remedies all these parties have in cases of breaches or defaults? The mortgagee's rights and remedies arising from the mortgage agreement, which are governed by the state of registration, as we said earlier. The most common are arrest of the vessel, possession of the vessel, taking possession, and eventually sale of the vessel. Not every country in the world has automatic rights to the ship, but to the mortgagee to take possession of the vessel. In Croatia, I think we introduced it only in 2004, I think, and providing that such a right is written in the mortgage agreement. Charter's rights, on the other hand, and remedies arising from charter agreement are governed, as I said before, by the law of their choice. In our case, let's say by English law, and his remedies are only two: to terminate the charter and to claim damages. So, when those both have rights and remedies in respect of the vessel, who is going to be served first? That's the core of my presentation today. Before going further, just now to summarize the laws which come into picture here. First, we mentioned the law of state of registration, which can be law of Marshall Islands, for example, because the ship This was registered there at the mortgage on the vessel. Then we have UN Convention on Mortgages and Liens, which also governs priorities, etc., etc. Then we have very important applicable law, which is Lex Fori, when the bank comes to a particular country to enforce their mortgagees' rights. Let's say they come to an English court and apply to English courts. The English courts will obviously apply English law when they are going to actually arrest and sale. So we have a common collision here between civil law and common law. For example, mortgage agreement can be covered by a law which is continental civil law, if the mortgage is registered in Germany, Norway, Holland, Croatia, whatever. And then we have common law, but is governed by, which governs the charter party, and which is governing law if you're coming to enforce your mortgagees' rights before the English courts. So all these things can cause quite headaches to barristers and lawyers and judges when they decide what should we do now. We have a charter party governed by, let's say, English law. We have Italian law governing the mortgage, and then enforcement is sought in the port of Rotterdam, and there are other claimants there, etc., etc. Now, it's all right when the mortgagee bank says, I'm entitled to take action to protect my mortgagee's interest. I'm going to arrest the vessel first and pay and seek the court to arrange the judicial sale because that's my right. But as we saw so far, that mortgagee is not only entity connected with that vessel. We have the owner and we have a charter. So when the mortgagee wants to interfere in order, well, when the mortgagee wants to take a legal action against the vessel, is he interfering with an existing charter party? That question was very much in the center of the Mirto case in 1977, which case was declared as the relevant, for some people, the most relevant English authority on this area of law. The questions debated there whether the contract impairs the mortgagee security, and whether the mortgagor is impecunious or willing to be and able to perform the function, which obviously requires very detailed analysis of facts surrounding each particular case. Lord Justice Brandon made a decision in that case, and which decision has become almost a general rule under English law. And he says the general principle is where the ship owner makes a contract with a third party, like a charter, for the employment of the mortgaged vessel, which implies that the mortgage was made before the charter, and the contract does not impair the mortgagee's security. The ship owner is willing, and the ship owner is willing and able to perform the contract, so everything is fine. Then the mortgagee is not entitled, by exercising its rights under the mortgage, like arresting the vessel, to interfere with the performance of such contract. So going back to judicial sale presentations we had the other day, I don't think it's as easy as it could look when the bank wants to enforce its security, because there are other people involved. They are not going to sit passively. Another component here, seriously being taken into consideration, is whether the charter was made before the mortgage or whether the charter was made after the mortgage. Most commonly, the charter is made after the mortgage because the ship owner to acquire the ship goes to the bank, provides financing. The bank first wants to see the mortgage on the vessel, then they provide financing. When the ship is in the hands of the ship owner, he goes to the charter to sign a charter agreement. So most commonly, mortgage comes first. But there are cases, or there were cases, where the charter was made first and then mortgage later, because the ship owner required further financing or whatever, so the mortgage was registered after the charter. Lord Justice Brandon, making the decision in the Mirto, relied very much on two quite old cases. One was in 1858 and the other one 1864. In the Matos versus Gibson, well, first few words about the Mirto, what happened with the Mirto. The Mirto was in 1974 acquired by a Greek company, and the ship was registered at the Greek flag, and obtained a loan from Claymore Benson Limited Bank, an amount of £2 million. And then 2 years later, in 76, I think, the ship entered a time charter with a Greek shipping line. From court's point of view, that charter arrangements were a bit dodgy for various reasons. And then the bank was getting nervous with a particular charter arrangements for their vessel. And when the ship arrived to Sunderland in the UK, the bank decided to arrest her because claiming that their security is being jeopardized by the action of both owner and the charter. The court was happy to protect the charter, to apply to the court for an injunction to prevent the bank from doing so, because if the bank is successful with the arrest application, it would cause huge commercial financial damages to the charter. So, coming back to this Lord Branson's principle that if the ship owner is willing and able to perform the contract, the mortgagee is not entitled to exercise its rights to interfere. That's the rule. However, taking all facts into consideration, the court found out that actually there were defaults on the loan agreement, the owner was late with payment of repairs to various repair suppliers. The owner was actually lacking money. Vessel was for a period of time uninsured, and the court decided, although we have this rule, the mortgagee's interest being jeopardized seriously, so no injunction, the bank is free to go ahead with the arrest and sale of the vessel. Similar thing was in 1858 with the Matos versus Gibson, where the charter was made before the mortgage, and the mortgage, they say, was fully aware of the charter, although notice of charter, formal notice, was never given to the mortgagee. But they say from other sources, the mortgagee was fully aware of the charter. And you see, all these things are, these days, in modern times, are all regulated by finance documents. There is a charter between such and such, up until come to that later as how these things should be sold up, resolved in advance rather than later. So what happened here is that the bank was not happy with the jurisdiction where the ship was at the time, and they wanted to move the ship to another port, which is more suitable for the bank to exercise their rights of arrest and sale. So they took possession of the vessel, probably by appointing an agent to do the job for them. And they were making actually actions to do that. The charter went to the court seeking injunction to prevent the bank from doing so. And the court was ready to issue such injunctions on the basis of an old English law principle, which I think we can find that principle in other jurisdictions too, that the acquirer of the property, here the mortgagee was seen as the acquirer of the property, it's their vessel, they financed it, which property already had an earlier contract in place, should not be allowed to use the property otherwise than under the contract or to the damage of the contract vessel. So the charter was safe. However, like in similar case, 150 years later, it was established that the actions by the charter were such that they were actually again jeopardizing mortgagees' interest and security. And although the court had sympathy for the charter, they had more sympathy for the bank security, and they allowed the arrest and sale of the vessel in the end. The other case to which Justice Brandon referred to was Collins versus Lamport in 1864. What happened there, that the bank was not happy with the charter's performance and the mortgagee's performance of the loan agreement. And they didn't arrest the vessel, but they made threats to the charterer that they would arrest her until things don't improve, and they will arrest the vessel when the vessel arrives to a different port. So in order to avoid that, the charterer was changing routes, going from one port to another, avoiding situations of that kind, but obviously creating damages to himself. He had a cargo on board the ship, etc., etc. So they, again, also went to the court to get an injunction against the bank, saying they are interfering in our business. We are suffering damages on a daily basis. We have to stop that. And charter was granted an injunction to prevent mortgagee from interfering and breaching the charter. But like in other cases, it was again on the bank's application found out that actions taken by both mortgagee owner and the charter were such that they were making securities very, very in doubt. So, as I mentioned earlier, what charter can do when they see the bank's action are going to actually interfere with their charter agreement, they are going to cause a huge financial losses. They can do injunction, apply to the court for an injunction to prevent bank doing so. Or if the arrest has been already granted, they can apply to the court for an order to release the vessel from the arrest and eventually to claim damages if they can suffered and prove the damages. Well, in cases of that kind, it's not only that the charter has been in problem. Owners sometimes are also in problem if the bank interferes in order to protect their interests. There was a case in Canada in 1990. Alexandros Saviris was the name of the vessel. And they were also making threats that they would arrest the vessel unless things improve. And the owners were saying this is all false. There are no elements or evidence that the bank security has been impaired in any way. And they went to the court in Canada, which decided that the bank was liable to the charters for the damage they had suffered due to unlawful threats to arrest. And the court found out on facts that the bank security was not impaired. Now, we are coming to a point, which I think I mentioned earlier. There is no contractual relationship between the bank and the charter. So what breach the bank is doing to the charter by arresting the vessel, which is owned by somebody else? There is no contractual relationship. The only potential base for the claim against the bank is tort. So, out of contract liability of the bank for doing actions which create damages to the charter. So the bank was not entitled to continue with the arrest actions. But then the bank appealed in Canada in 1992, I think. And during further investigation of facts in a court of appeal, it was found out that the owner was actually incapable to perform the contract for various reasons. But most of it, the bank's conduct was not qualified as a tort in Canada under Canadian law. To commit a tort, you have to have some unlawful intentions. But the bank will say, no, intentions were not unlawful, intentions are to protect our security. Exactly. So there was no tort, and as a result, the bank was entitled to take action against the vessel. However, slightly different situation might appear when the owner is having trouble because of banks' interference with the contract, time charter contract. And this is, I'm not going to many details of that, but just quote as a paragraph from a good book, Maritime Law, published in 2003 by Christopher Hill, that is called Dubrovnik, when he says that the arrest is wrongful and mortgagor is entitled to claim damages, where a mortgagee who wrongfully arrests the vessel on the grounds that his security has been placed in jeopardy when it had not been so placed. You see, the bank might think so, but it depends on really facts established, whether that was put in jeopardy, whether security was put in jeopardy or it was not put in jeopardy. And also, mortgagee who wrongfully prevents the mortgagor from exercising his power of redemption. Every debtor has a right to repay its debt. But there are situations where some mortgagees are acting in a bad manner. They don't want to take repayment of the loan or earlier repayment of the loan because they are much financially better if the interest carried on the loan. And in cases like that, the mortgagee should not be entitled to take action for that security. Now, coming to how all these troubles can be avoided in advance, I call them safety nets. For example, knowledge by the bank that the charter was in existence, or knowledge by the charter that the ship owner is going to grant a mortgage to the bank, to its bank for certain further financing, written notices about that, confirmation of acceptance of notice, so everybody knows everything, whether the charter was made before or after the mortgage. There are so-called priority or subordination agreements whereby, for example, charterer agrees to subordinate all their rights to the mortgagee. There are owner's letter of quiet enjoyment sent to the charterer, practically saying, yes, we are in a charter agreement, but this ship is mortgaged to my bank. If in the case that the bank takes an action in respect of this vessel and it causes you trouble, I'm here to deal with that. Same thing can come from the mortgagee's letter of quiet enjoyment to the charter, saying if default under the mortgage occurs, before we take any action against the vessel, we shall notify you, we shall give you 15 days to try to sort it out. We shall notify you about our actions, we shall not, some form of coordination and among the charter owner and the bank can be put on a paper to avoid all these situations I was talking about, and rather to wait for the court's decision that the parties decide what to do with these circumstances themselves. And that brought to the end of my presentation.